Good evening, namaste. I welcome you all. My name is Surya Prakash Soni, and this is a VICHAR webinar for Indian diaspora, for the wider diaspora in Victoria. And the initiative purpose is to bring speakers from diverse expertise onto this weekly webinar every Wednesday night, 9 to 10 p.m. I firmly believe there's a huge pool of talent in the community, in the diaspora in Victoria. We can learn from each other, we can share our knowledge, and we can avoid making mistakes one or every one of us make it over the time, but we learn and improve as a community together. Uh, those who are watching it on YouTube, please like and subscribe. By doing so, you are spreading the word, you're bringing more, you're sharing this knowledge to wider community, as well as attracting more speakers to come on this weekly webinar. Without further delay, I welcome all our speakers. Welcome Neelesh ji, Neelesh Mehta ji, Vikram Jain ji, and Aakarsh Shah ji. I'll give just very brief introduction because I've been told that there's a lot to cover today. So I'll start with a very brief introduction for each of our speaker. Vikram Jain ji is a tax advisor who helps client make sense of SMSF, tax and estate planning. We also have Aakarsh Shahji, and he is a solicitor making legal work accessible and understandable to everyone. And last but not least, we have Neelesh Mehta ji, a professional who brings a breadth and depth of experience in capital markets, financial services in Southeast Asia, particularly India, in Australia. And he's passionate about community and education. Neelesh is a fellow of Institute of Company Directors, a fellow of Chartered Accountants Australia. He is a board member of RSPCA Victoria, RSPCA Australia, and also CFO and board member of Texas Peak Group. He served as chairman of Gawler Cancer Foundation, vice chairman of Futurity Investment Group, and invitee to the government committee for Samarinda Ashburton Age Services. And I'll add that he's also founder chairman of We Ride Australian Cycling Promotion Fund, and he's a managing director of Jaipur Asset Management. With that, the reason I did this elaborated because what a gem of personality Neelesh ji is in our community, and he's been a board member at age of 25, if I'm not wrong. Neelesh ji mentioned earlier. So that's a talent we have in our community. We want to learn, directly listen from the horse mouth here in this forum. And without further delay, I hand over to you, Neelesh ji, to do any further moderation of the fellow speakers and see how we can cover those topics and maybe briefly describe what we are going to talk about today. Over to you, Neelesh ji.
Thank you, Suryaji, and for a very extensive accommodation. But yes, I'm just a nice person, I believe. At least my wife doesn't think so. But yes, and I hope to be able to be of value to everyone. Now, I'm a little bit out of place here because there are people on this panel listening in today who have far more experience and knowledge than me. So I won't call out their name, but I think we all know who we are. So thank you for joining us. It's an honor to be here. And none of this would be possible without, the immense effort that Aakarsh ji and Vikram ji have put into trying to do this work. And this all began with a few months ago, where we all were saying there are issues about our living here, and people don't realize, but a will is not just about your assets. The assets your family will fight over, sort out in one way or the other. But it's more than that. It is about simple things. Who's going to keep your Facebook account? Who's going to keep your great-great-grandmother's small piece of something that he has handed down over generations? The next generation may not even know what it is or what sentimental value it has. There's, of course, the tax liabilities, how to be efficient with tax, and a myriad of other things. Have you got your medical power of attorneys? Have you got your super nominations? There's a whole myriad. But I'm not going to raise that. All I'm going to say is that I'm going through it myself, so it's not simple. And I thought, well, if someone who understands finance can't do it, well, good luck to everyone else. On that note, I was very, very lucky to have people like Vikram Jain and Aakarsh to help out. So they very kindly have donated their time today to have this conversation. So thank you, gentlemen, and thank you everyone for joining us. So let's kick off. Vikramji, can I ask you in one line, why does someone need a will?
Will is basically your list of beneficiaries who are going to benefit from the assets which you own after, say, I die. Who am I going to give my assets to? It may be given to one person, or it may be given to a number of people, specific assets and all those things. So yeah, basically will is a written document whereby you clearly mention who is going to get what.
Very
And that
nice.
is after the death. So will does not get activated until, so yeah, we have to die to get the will activated.
Absolutely. And where there's a will, there's a way. That's what everyone.
Exactly.
Well, your friends have a slightly different will to it, but I'm sure there's a way there too. I just want to make sure everyone understands none of us are licensed. This is only general advice. This disclaimer should be very clear. It is essential that you take your personal advice based on your own circumstances as
Yeah.
appropriate. Only general advice. Akashji, over to you. What are the three most essential components while preparing a will?
Just unmute me. Thank you, Neelesh. The three most essential components would be um, executors. So who will execute your will when the time comes, right? Beneficiaries and specific wishes, or I would say, for instance, if you don't want something or don't want anything to go to anyone, you need to make that specific. So being specific about your wishes, executors, and beneficiaries, these three are, I mean, there are many other important parts of a will, but to begin with, yes, these three would be what I'd say for now. Yes.
Absolutely. And an executor is the person who will complete after you die. I'm sure you won't come back to sort it out. So someone needs to do your wishes. And that, in simple terms, is the executor. Now, most people write the executor, nominating Nilesh as their executor. This was done 25 years ago. Nilesh has died. He's still the executor on your will. You've seen a few of those. You told me, Aakarsh and Vikram Jain.
Yes. Yes.
Yes.
An important part of it is, yes, find out who you trust, why you trust them, who will do your bidding. Now, that executor may be for a fee. It may be someone you trust who will do it for without a fee, but essentially you're giving your entire estate and all discretion to that person to do your willing. So, first exercise, Akashji, I think you asked was everyone, can you spend 30 seconds thinking about who your executor could be? Put two names, because if the first one is not there, at least let's make sure there's a second person. This was Vikramji's suggestion.
Correct. Yeah. We call it successor executor.
Fantastic. Successor executor and executor. Let's spend 30 seconds thinking about it. Please write it down. While we're doing that, beneficiaries, Akashji, who cannot be a beneficiary?
Well, to the extent that will goes, because will is when you're making a will, you're not restricted by any particular limitations, which is basically your wish is there was a saying which I'm trying to remember, but basically a will is a list of your wishes, and if you wish for anyone to be a beneficiary, they can be a beneficiary. So there is no restriction on um, per se. There's no restriction on of yes, if someone is not in the mental capacity to be able to inherit your assets, then it's a different situation. But you can still have them as beneficiary through by creating a trust for them and using the trust money to be using the trust as a vehicle to be used for the benefits of the eventual beneficiary. But it can be most people, of course, when in an event when something unfortunate happens, most people want their estate or their inheritance to pass through their kids or their partner, sometimes their parents. And that's what, and people think that's what it's limited to, but it can be, say you want to donate certain amount of money to your school because you have a lot of gratitude for it. That can also be added as a beneficiary. And so, and of course, simpler you keep it, the better. But yes, anybody and any organization, individual can be a beneficiary. A lot of times, churches are beneficiary when we work on wills of, especially people born and brought up here who may not have a heritage or may not have successors. Churches become their beneficiaries as well.
Very nice. Thank you. Thank you. And I'll make it an example. I've worked with a few charities where we've got 6, 7 figure donations through wills, and invariably they're subject to challenge. So it's really important to get your will drafted very carefully so that if there is a challenge to it, your will, your decision can be executed without being challenged to a large extent. And I'm telling you, as a charity, we've received 6, 7 figure donations, which are invariably challenged by the family. The key there is to explain why Nilesh ji will not be getting anything from your thing or why he's being given something. The most important thing, Vikramji, is the tax effect of it. Would you like to suggest one example of how you can save a lot of tax if you do it properly?
Yeah, so I've got an example, and in fact, one of the attendee actually put that problem to me. I won't give the name. The attendee's friend, he was doing lawn mowing and he died recently. And in his will, he put 50% to his spouse and 50% to a daughter. And the thing is, when your money is going to your spouse, it goes tax free. But if it goes to your children, and if the children are adult, so basically they are more than 18 and they are not dependent on you financially. So even if they are working somewhere, they could be considered as not dependent on you, in which case they will pay 15% tax on the taxable component of your super money. So kind of that is where the tax planning comes into effect, that you need to ensure that whatever beneficiaries you're nominating, whether it is for your super money, which obviously doesn't directly come through will, but kind of has a tax effect. The other part of the tax efficient way, if you were considering, there are set strategies where, lawyers and we as accountants suggest to have testamentary trust for the benefit of the, family members of the, obviously the deceased. So, if I'm making the will, I could make a will saying, on my death, a testamentary trust is created for the benefit of my wife and my children. And my wife is the controller of that trust, and she could distribute the profit from that money, which will go into that trust, to herself and obviously our children. And if the children are under 18, still they will be taxed at adult rates because the money is inherited money. So it's a special provision where normally minors are taxed at almost 47% from the, just hypothetically, very first dollar. It's actually $417. They don't pay tax. It's a very nominal amount to worry about, but they pretty much pay 47% tax on all their income. But if the money is earned through inherited money, like I explained in the testamentary trust, then they almost get tax-free threshold. We have done this for our clients, and they've saved so much tax. Um, Obviously, it all sounds very difficult that, oh, there is testamentary trust created, etc. My suggestion is whatever you do, you have your family doctor, you have your family lawyer, family accountant who can take care of all this even after you're not there. So that way, he can bring everybody in sync in what you have done and what is the purpose of you doing this, so that long term they can get the benefit. Otherwise they might just get too scared by the terminologies and start thinking, oh, this is going to cost me too much. I can honestly tell you it doesn't cost you that much versus the tax you're saving. It's cost versus benefit. If you analyze, the cost is nothing.
And Vikramji, you made a very good point. I come from a house where we don't risk a nominal amount in fees. You save 1%, not even 1%. Sometimes it's 0.1% of your asset. A goodwill can cost a reasonable amount of money, but it's not going to be a fortune.
Correct.
Cost of not getting the will right, you're risking all your assets, not from now, but 10, 20, 30, 40 years from now, when it'll be a substantial amount.
Mm,
Well,
exactly.
you're saving a few hundred, maybe a few $1,000s now and putting a very big pool of assets into the wrong hands. It's a very high risk, but just be aware of that.
Correct.
You-
The other advantage of having those trust structures is to protecting it from your non-bloodline beneficiaries, which means, partners of your children. Obviously, if a divorce happens, hopefully it doesn't, but if it happens, then at least you want to protect your estate. So, but nobody's really after the money of your family; they are for the love of the family.
Absolutely, absolutely. And I'll give an example. Someone raised the issue of a crypto. So there was a gentleman in Glen Waverley who died suddenly. The wife reached out to someone who was their accountant. His only asset was he had a large quantity of Bitcoin.
Mm,
Now, this person died suddenly of a heart attack. We've heard enough of those stories where people suddenly die. This
mm,
young man in his early 40s died suddenly of a heart attack.
mm,
His wife had no idea whatsoever how to access those Bitcoins. Her accountant called me up and said, Nilesh, I've got a problem. Now, the only fortunate thing this person did was he actually shared his access codes and passwords with his wife.
mm.
But even then, you think she knew how to take out Bitcoins and encash them? Now, one Bitcoin is what, 150,000, give or take, Aussie dollars? Can you imagine if he had a few Bitcoins and he's just died, how important that money is for his wife who's, got all kinds of commitments?
Exactly.
Now, we were fortunate we were able to get someone to try and help her learn how to do it and access those funds, but that was her whole asset, her whole life. So good on that person for sharing their passwords, but can you imagine what your wife or your next of kin or your kid goes through? The first thing you die, just picture yourself, I've just died today. What is the first thing my wife will need to arrange for my funeral? Can you put it in a will, Aakarsh?
Yes.
Can you
Your
plan for
funeral
it in
wishes.
advance?
Yes.
Do we plan in advance? We all think we will live till the next generation or two, right? Or we may even be, we may not die at all. That would be fantastic for some of us. But you get what I'm trying to say? We assume longevity of life, which is great, but we need to prepare for the difficulties. And that's where people like Aakarshji, Vikramji, and a few others here who have gone through these journeys need to help us. The second most important part in these conversations is how do you start? Don't get bogged down. Vikramji told us, do not get bogged down by making a list of assets. That's the most informative and wise advice I've got. We usually start with who does this asset go to? Do not worry about that first. First thing is to find out who it should go to. Don't worry about which assets goes to whom. Get the template right. Get the right person to execute your will. Get the right person to draft your will. Talk to your partner about what is it that you want to protect.
Absolutely. And just with Nilesh, with the example that you gave about the person in Glen Beverly, uh, just for a second, imagine if he hadn't shared the passwords or the access codes, what would be, maybe the family would have tried, of course, but in their heads, what would they be thinking? That, oh, he left, but he left with a mess.
Yep.
So, and it is obvious when we are alive, we are, of course, anyone is remembered more after they die than when they are alive. And when your family remembers you, you don't want to be remembered as someone who left a mess. Uh, Most importantly, we all of us work 20, 30, 40 years to make what we, and we are so careful, right? And I mean, we all have insurance for the house, we all have insurance for the car, so we have all these safety measures for when we are alive, but zero safety measures we, when we will not be alive. It is it is surprising, that this is how things work, and it needs to change, of course.
Fantastic, and thank you for that. And I'd like
There
to
is a shloka, Nilesh, if you don't mind, just a
ask
quick one.
you.
It says, Yad bhajati jivite kartavyam, tadapi marane api chintiniyam.
Very
That
nice.
means what one must do in life, one must also think of after death.
Mm.
Very nice.
So I think almost what Akarshi said just
Absolutely.
now.
Absolutely. Now, Vikramji, can I ask you a question? I've done my superannuation and I've put in what they call a binding death benefit. If I do not put in this binding death benefit, I'm told my superannuation does not go to the people I want it to on the basis of my will. Is that a correct understanding?
That is exactly right. So SMSF or super fund money is governed by basically the trustees need to receive a nomination from you. Nominations are two kind. One is just a nomination and the other one is a binding death nomination. When you just do a nomination, it becomes discretionary for the trustee to act on it, or they can just choose to decide who are the best beneficiaries they think it should go to. And we can give you an example what could happen there. Probably you would know those examples too, Nileji. But if you do a binding death nomination, what it means, it binds the trustees legally to follow that nomination. And if in that nomination, if you mentioned your wife as the beneficiary, then it will go to wife. If you mention your children, it will go to your children. Or you can mention your deceased estate or legal personal representative. That means it will be then flowing through to your will. So basically, all the super money will be passed on to the executors of your deceased estate, which is basically governed by your will. And then, based on what you have mentioned in your will, if you mentioned, and probably that's something Akarshji can explain better, but if you mentioned super benefit is to be given in a specific way rather than falling it in the part of the total estate, then it will be dealt with that way. And obviously, with super money, the death benefit, we call it super death benefit, you'll always have to remember the tax part of it. There is a tax of 17% if it goes to non-dependent tax beneficiaries. And if it goes to dependent tax beneficiary, which your spouse is always considered as a dependent tax beneficiary. So if it goes to your spouse, whether through your nomination or through your will, so your binding death benefit nomination says it goes to your estate, and the estate says it goes to your wife. Still, it will be tax free. So you just have to be careful about that. But look, end of the day, tax should not drive your intentions, because if you don't intend to give to your spouse, you don't bother about tax, because tax is one part of it. But important is whom you really want to benefit from that money. So that's also important. When we talk tax, I always tell people, don't make tax as your only motive to do something. It has to fall in your full picture, because if you're ticking only that box and all other boxes aren't ticked, it doesn't work.
So, Vikramji, when I did my will, Prakashji will take questions at the end if that's okay, and we would avoid any individual. We can take, will just be a general level, all right? But I'll just give you an example where the typical thing is I'll give my estate when I die from my superannuation to my wife and two children. The two children will have to pay tax because they're no longer dependent. So there goes
Correct.
17% of it. And I
Yeah.
believe they will not be able to access it until they become 65 or whatever age they have to retire in.
No, no, that is not the case. So they will get the access, they will be able to access it straight away.
Yep.
It's just that they will pay 17% tax if it goes to them directly from your super money. But if it goes through your deceased estate, which means your estate, which your executor will manage, then they'll pay 15%. So there is a 2% saving, just a small tip here, that you could at least still save between 15 and 2. Again, 2% on a big amount is a
It's a
lot of
lot of money.
dollars. It could be almost like a car, you know.
Absolutely.
So yeah, it
And Vikramji, do we have to renew these the
binding death nomination should be done every 3 years. And anyway, even a will should be, done or at least reviewed every few years. Again, Akash would be the better person to talk about it.
Yes, I think 3 years is a good amount of time to review the will. And when we were kicking off the conversation, I remember hearing that like redoing or reviewing the will costs a lot of money. It doesn't really. So that's where what Nilesh was saying in terms of um, maintaining the assets. So generally, there is no need for the will to have a list of your asset because the asset will change over time. So as long as you've got a will which covers who the benefit should pass to, who should be executing those all the wishes in your will, that's and unless and until that changes significantly, it just needs to be reviewed and then it just needs to be changed and executed again. And one important factor to note when about the question that was raised earlier is that a will should have at least two witnesses sign it. But if somebody is a beneficiary in the will, it is best not to have them as a witness as well, because that's also a common ground for challenge. So these are some of the, I would say, practical tips. But 3 years reviewing of will is, I think, is fair and square. You can do it earlier if you're like, if your assets have changed significantly, or if your relationship with the beneficiaries have changed significantly, or you can do it later if things have remained as is.
Very nice. Thank you. Thank you, Akarshi. And very rightly said, we usually don't even think about who's witnessed our document. And if your wife, who's a beneficiary, has witnessed your will, well, it's liable to challenge. So it's worth getting a right solicitor to look at this. I'm already facing a case for someone I know who had exactly their whole trust deed has been invalidated because his wife signed the family trust as a beneficiary. Okay. I'll ask one more question, Akarshi, about what happens to my death wishes? Like, for example, I do not want to be resuscitated medically. Is there a way to put some sort of binding requirement that my family does it in a particular way? Like, I would like to die at home, for example. I do not want to be revived at a right age where, you basically, when you revive due to a heart attack or something, life could be with a few broken bones and an unnecessary extension. Some people need it, so some people may not want it. Can I give directions and how do I do that?
Yes, you can, and depending on the state in which you are, the law will either apply or not. And in this is in cases because here mercy killing is allowed. That's why it works differently when you are going through a terminally ill and your body is sort of dead but the mind is not. But that's in rare situations. In most cases, yes, you can have wishes such as do not restart my heart unnaturally, if which is what Nileshi talked about right now. And you can, if your wishes, because when, of course, if you die a sudden death there's no problem, but if somebody's dying a slow death, or somebody's become um, has lost the power to decide or speak, or consciousness, then a lot of times, how many times, like when, at least when I was growing up, I saw so many people, old people, and I felt like, man, they have been in the same state for like 7 years. Why do they not, they have been in the hospital, they have been in a coma, they've, like, you see some people have been in that state, but because of the wishes of their successors, which are generally emotionally driven, they continue to suffer. But if you have a certain a certain wish mentioned in terms of your death wishes, yes, it is important that your executors, or they will look at the will and definitely or try to honor it to the best it can, as long as it doesn't go against the state laws.
Fantastic. And Akashi, I'll share with you, I actually went through a similar process for a very close family member. The last thing you want is to be taking that decision on whether the hospital should take you off life support or not. No family member who's left should be left to take that decision.
True.
That is a decision you can ask them to keep you on life support or not keep you. Make sure you dominate because they are so fragile at that time. It's a decision you wish no one has to ever take, but it's within your rights to write that decision and make sure they follow it. And the most important part, Vikramji, no, Akarshji, you were telling me that I did all my will. I put everything and I sent it to my solicitor. I signed, executed, kept it perfectly. Vikramji's my executor. I put my binding nominations. I put everything in place. But I didn't tell anyone about it. What happens then?
I mean, a will which nobody knows about or nobody can find is almost like having no will. It's un
Really? That's
and
very exciting.
it generally is too late until it's found or discovered because so people that's one example or case I was referring to where like, oh, I've kept my will in a safe. Will is not something to be kept safe. Of course it is something that you keep safely, but it's not something where you put it in a bank locker with three keys and not tell anyone. Then how are people going to know that you have a will? Luckily there are digital tools now where you can register, and there are will finder services as well which can find wills by doing a search. But again, why would you want to leave a mess? And I'm sure we'll come to this section as to in terms of the, I think the most important reason why a lot of people would like to make wills is guardianship. Making sure that the children are taken care of well, which Nilesh will cover. But yes, will is not something where it's not like a I don't know, it's not a 500 bitcoins where you keep it in a locker and in a hard disk and not tell anybody about. So yes.
No, no, and especially in our community, we tend at least not to tell about anything. But then there's the other side of it that I don't want to let my son know about all the assets he's going to receive. He starts spending in his inheritance before he receives it, and he starts praying for my death. We don't want that either. So there's a balance there. You need to tell someone about it, someone who can be trusted. The executor is a good person to start with.
Yep.
And there are ways to record it so that people contact you. And then don't forget, going back to the medical point of view, that you've also got your body. Some people want to donate their organs. I'll encourage you to think about that and register for your, organ donation. That's important for some people. Um, you raised the issue of children. So let's take a scenario. I've got two young children, 15 years, well, let's make them 10-year-olds. Okay? Both me and my wife have just been hit in an accident and we've died. Their grandfather is usually, or my uncle is their uncle is their usual person who will assume guardianship, but they're based in India. That's a problem all of us will have, right, Akarshji?
Yes.
How long will it take for a visa usually for my father, who's 85 years old, to come to Australia?
Minimum a month's time.
Okay, so in that 1 month, what happens to my two 10-year-old children?
For the Australian government, the welfare of the children is of the paramount importance. And the way we see welfare of our children, unfortunately, the government doesn't see it the same way. So I mean, unfortunately, they end up getting into foster care, and they become property of the state because the state thinks that it is their responsibility to take care of the children. And we all know, or if we don't, we can look up a lot of articles about how the foster care system works and why it is just like prison. It is a system designed to bring money and generate revenue. So that's the extent we don't want either, even if we have $100,000 worth of assets or $10 million worth of assets, our children to parents mean exactly the same for each and every parent. So you don't want to be in a situation where you've not left anything or any directions for the court to follow, because if you don't leave the directions, it for your child may it be for your children's guardianship or distribution of your assets, the court decides what happens.
So it's absolutely essential to say who is going to maintain guardianship in the interim period after your immediate death until someone who you trust, who you believe in, who may be family, can look after your children and their needs. That's absolutely essential. And most of our younger cohort don't really pay attention to it. That's absolutely important.
And Nilesh, to the extent where, if you have a will, you can, just like a backup executor or a backup, what was it, Vikramji? I forgot. A backup, yeah,
Successor executor.
a successor executor. You can have a backup or a successor guardian for your children as well. And in your will, you can go to the extent where if your children are under 18, you can give directions to the guardian that raise them with the principles of so and so religion, raise them, give them so and so education. Of course, they won't go against the children's wishes, but imagine they end up going into a foster care where they're surrounded by, for instance, nothing against any religion, but Christians or some other religion which we don't follow. And your legacy is completely lost because they never got to learn the ways which you wanted to teach them. So the will, when you have a will, you can even go till this extent where you can say my children should be raised under this belief. They should be taught these things until they turn 18. After that, yes, you have very limited control. But I mean, sure. I mean, the way somebody is raised until 18, they naturally like to follow that route in most cases.
Absolutely. Absolutely. And I'm just fascinated by the amount of, different conversations that are coming up. Are these all likely to be covered in an online will that you would offer, Aakarsh?
Yes, no, not really. Online will is, I'm trying to find an example, but online will is more like a Panadol.
Yep, every doctor
So
uses it.
yeah,
And it really
and no matter what kind of headache or what kind of ache you have, you take a Panadol, and we call it Panadol solutions, which is still better than not having. So if you're someone who doesn't have time, who doesn't really care, or you're like, you know what, I'm just going to mental peace, I'm just going to get an online will. A bad will can also cause a lot of problems than not having a will at all. So just it's like a stitch in time saves nine, and a bad mango creates makes every other mango go bad. It's very similar. We've learned this whilst growing up. So many these all these basic principles. So yes, online will can be quick, easy, and cheap, but I think cheap solutions often end up very expensive in the longer run, as we all know it. So yeah, there are some good tools, but definitely if you're, it's better to not have Panadol for all aches. Get a proper assessment of your situation, and it doesn't, as Nilesh mentioned, it's not like making a will costs $5,000. I mean, it's not, it's not that. So yes.
No, appreciate it. And again, reminding everyone, this is general advice only. We are not licensed to give any advice. Secondly, none of us here are seeking any reward or asking for any business. We want to make that absolutely very clear. Please consult your valued consultant. Please consult your accountant, your solicitor, whoever you have faith in. But the request from the three of us is to please consider the aspects of a will. Now, there are a few questions. If I don't mind, I'd like to take it up, and maybe we can have about 15 minutes for questions and answers. I'll request you to keep your questions to within 30 seconds, and our replies, I'd request our two members to keep them within a minute and stay away from any personalized advice, because bad advice is more dangerous than no advice usually. So just be careful on that, right? So I'll just go through some of the questions. If anyone has
Just
any.
to add to that,
Yes,
Nilesh, I
please.
think what happens is sometimes, we also get clients saying, oh, so and so person told me this. And basically, they don't tell us what facts and situation were provided when they got that advice from so and so person. So, it's not like, copy paste solution for a lot of things. And anyway, even if you get it, you need somebody to know your will, to know to execute it. So it's best to get it done with professionals or at least your known and trusted people who are, because after your death, unfortunately, we cannot come back and fix it.
Absolutely. Absolutely. And if someone finds a way, I'd like to know about it. I may want to. All right, I'll just go through.
Yeah,
I'll just go
from
through a
the
few.
chat questions you can
So
pick.
if anyone has any questions, please put it in. We'll try and attempt to attend to as many as we can.
I think that question, just I wanted to say that probably we did not expressly mention, but it was definitely medical power of attorney, whereby you express your wishes about what you want to do, what you want to, if you are in a medical situation. I think that's what Aakarsh mentioned. Definitely, it's a medical power of attorney you do, and normal enduring power of attorney is your for everything else, which includes your finances,
Absolutely.
which all comes into play as per that attorney. It is a very complex document in itself. Again, maybe Akarji, you can take it further. I just wanted to clarify that chat message. Yeah.
Yeah, and I think that because a couple of questions are on similar lines, yes,
Mm.
a will only comes into effect after a death of the person. But if you become mentally incapacitated or physically incapacitated to take decisions, then generally with will, when somebody makes a will, normally the superannuation binding nomination, that's not a document. It's a process to follow, and you can do that. But along with will, enduring power of attorney and medical power of attorney, these are the two documents, and of course, the third one is superannuation binding nomination, that are generally prepared because enduring power of attorney gives powers to someone who you trust to take decisions on your behalf for matters other than medical. Medical power of attorney gives someone the power to decide, and you can in there you can have I can add something called an advanced care directive, where you can have specific items listed, such as what would I want, what preferences do I have when my life is ending. So do I want to die in an hospital or just take me home after the death? In what manner or what religious or ceremony to be done so after my death? So these all you can have in the advanced care directive document. But there are, so, and more often than not, along with the will, if you consult someone who you trust, of course, they would generally give you these directions to get these documents made together as well. So then you're fully covered, no matter if it's death or mental incapacity.
Thank you. Very nice. Can I just go through the questions
And
quickly?
just sorry to just add one more line to that is executing these documents properly is of paramount importance. Like, don't underestimate. You can do everything right, but I think just you mentioned it previously that if not executed correctly, the whole effort is gone wasted.
Absolutely. Now, I've got a question about a testamentary trust, which we touched on, but can I leave that for you to do after this question? The second question, also to you, Vikramji, is a complex matter on super and taxation when the superannuation is distributed upon death, whether it goes to the estate or not. Again, superannuation is very complex. It has issues around age, what stage you're in, where the money's coming from, etc., etc. But on a very high level, Vikramji, if you can just give an idea of how super is distributed and what tax could be there, and secondly, what a testamentary trust is, please.
Okay, sure. So on death, if super money is going to your dependents and dependents, tax dependents basically, and the definition of tax dependents says it includes your wife, your children under 18. I'm pretty sure it's 18. It could go up to 25 if they're still dependent on you, but you have to prove their dependence on you. If it goes to them, it is tax free. Obviously, there are components of super. Again, it's complex. I won't go much in detail, but the taxed component of your super fund, that is what is taxed at 17% when it goes to your non-tax dependent beneficiaries. So that's the tax part of it. Testamentary trust. Normally, sorry, just one more suggestion, and obviously take advice from your accountants or whosoever. Obviously, if you've got your partner there, and if you want to give that money to your family, still I would recommend why pay that 17% tax? Just give it to your partner and let your partner do what you want to do, so long as The partner is going to follow your decisions. Again, this is a very general suggestion. Don't make it like this is what I said. You have to discuss that internally between family members and do it. But you could simply save that 17% by doing that. Secondary testamentary trust is basically a trust which comes, I call it activated, which is activated if you have provided for that trust in your will, which means your will say that on my death, a testamentary trust will be created for the benefit of so and so person as the trustee and so person as the beneficiaries of the trust. That's what that trust is. Normally, we do it when we are discussing this with our lawyers or with our clients. We say to them, if you want to give it, say, a lot of grandparents want to provide for the education for the grandchildren. Normally, their children are adults. Just if I'm a 60-year-old person, my child is an adult, but I might be thinking for the education and funds for my grandchildren. If I set up a testamentary trust, then that testamentary trust can receive my money, which is the inheritance, into that trust and can be invested in such a way that that earnings can be used for the school education of the grandchildren without them needing to pay tax up to, say, currently it's around up to 20 grand. Each child would not pay tax, even if they are minor. So again, this is general advice. I'm just giving ideas so you can discuss with your accountant.
Absolutely. And if I can add on it, if it's your grandchildren, there's a product. Again, I used to be their vice chairman, but forgive me, I cannot but say, but you can actually do it in a tax efficient way. There's a company called Futurity. Look at their education bond. It's like a family trust which cannot be challenged under any circumstances and can be used very effectively. It's like paying pre-tax. It's like salary sacrificing for your school fees or for your children. So that's another way to look at it. Again,
Good advice, good suggestion.
I put a
What's the name?
disclaimer. I have worked for that organization, so take that with a pinch of salt. Find your own, get your advice before you do it. But yes, that's something interesting. There's another question on tax that's very interesting because everyone's really concerned about tax. I think you guys have done a fantastic job. They're not considering about their end of life, but tax definitely. How is the property asset considered in the tax perspective for their beneficiaries? Vikramji, I think this is yours.
So just a simple rule you have to understand. Tax is not payable when you give your assets to your beneficiaries. So on death, when your assets get transferred to your beneficiaries who are provided in your will, there is no tax at that time. Tax is when they sell that asset to a third party. So if the assets are going to them because you gave them through your will, then there is no tax on it. So I hope that answers that question. That's actually an easy one.
Thank you, Vikramji.
Sorry, a disclaimer, unless it is going to go to a charity and other things, then there could be some valuations and other things comes, but we are not taking exception items here. But generally speaking, there is no tax payable on transfer of assets to the beneficiaries who receive those assets by way of inheritance. It's only when they transfer those assets, there is a capital gains tax or any other tax. Sorry, yeah.
Thank you. And someone asked, is there inheritance tax? There is no inheritance tax applicable in Australia. It is becoming fashionable, especially in the UK. But if you're an Australian resident with assets in the UK, there could be implications. But yes, as of now, there is no inheritance tax in Australia. But the way the world is going, I think it may be a matter of time before it also comes in. Don't forget, some of us are planning for 30, 40 years from now. Yes, there could be inheritance tax. So there are ways to structure your finances depending on what complexity you're willing to take, so that even then there is no inheritance tax. There's ways to do it. So again, that was one more interesting question. And yes, someone mentioned minors, unsound mind, people of unsound minds, prisoners, basically incapable because of a disability. They may not be executed. Thank you, Vinay, for bringing.
Yeah, they're called disqualified people. Yeah, correct.
Absolutely.
Nilesh, I've got few questions of my own built up
Please
from
go for
this.
it, Suryaji. Please go
Yes.
for it.
So they're all technical general purpose question, not specific to
So
anybody.
after you, Kageshji seems to have a question. Kageshji, can you put it into the chat if possible?
Or you can unmute. That's okay. Kageshji can unmute if he's finding difficult to type. Kageshji can unmute and ask a question. You're on mute, Kageshji.
You're still on
Kageshji,
mute.
you're on mute, Kageshji. Yeah.
Yeah. Just a very quick one. You said there is no inheritance tax just now, but when the money is distributed out of super or assets are distributed from super, they will be taxed for dependent children. So isn't it good
Sorry,
to leave the
that's not inheritance tax. Inheritance tax, for example, in the UK, you pay 50% of the value of your assets as tax
Upfront.
upfront.
No, okay. My question was, if we nominate our super fund to our estate, to the deceased estate, so the super fund money will go to the deceased estate. Will it be taxed to the deceased estate, or it will not be taxed? And if it is not taxed, isn't it then going according to your will to your children who may be tax independent?
Vikramji, you want to
So
answer that?
basically, when the super money goes to the deceased estate will call it as its income. So just understand the step. It is income of the deceased estate. Now, if that super money from your deceased estate is going to go to a tax dependent beneficiaries, then it is not taxable income of that deceased estate. But if it is going to a non-dependent tax beneficiary, a tax non-dependent beneficiary, it will become taxable income of the deceased estate, on which deceased estate will pay 15% tax.
Okay, so that may be one way to instead of making a separate nomination for super and separate will for the out of super money or assets, isn't it good to just pass it to the deceased estate and which becomes part of the will and therefore distributed according to will? So you only make one sort of will with all the complications added into
You
it.
still need to make a nomination though. You still cannot avoid doing the nomination. You
Yeah,
still have
so
to
can
make a
you?
nomination to the super fund telling them that your super benefit needs to go to the estate, which we call it as a LPR, legal personal representative. So you still need to make a nomination. So yes, in a way, you are right. But again, you still have a choice to do this way or that way. It is again an individual decision. Again, need to consult with your advisor. It may be right for you, but it may not be right for somebody else. So we don't want to make it as a general statement.
Absolutely. And
Yeah,
Vimalji,
what I meant was in a simple way, instead of making separate nominations for super amounts and a
No,
separate will
super,
for
you
non-super
still have
amount.
to make nomination, Kageshji. That
Yeah,
is what I'm
no,
saying.
I can nominate my super to my estate,
Yeah. So
which
that
is
choice
simpler,
you can
and
make. Yes, that choice you can make.
then choose my will accordingly,
yes,
so that
Yes,
this
correct.
estate can be distributed in one will rather than a separate will in a separate nominations under super
yes,
to
that's
people.
Again,
Yeah.
there could be reasons
Okay.
for not doing it that way too. So we don't want to cover that here because it is again a situational thing.
absolutely.
Okay.
Thank
And
you.
Vimalji, you're absolutely correct. Each jurisdiction's laws are different. Your wills need to comply with each jurisdiction. So don't be surprised if you have to have 4 wills because you have assets in 4 different countries.
Like India.
Absolutely. Suryaji, we've got time for
Yeah,
about 2
yeah.
questions from you. Let's
That's
leave
okay.
it at
Like
that.
few minutes over should be fine if you don't mind. But I'm asking very critical questions. One is, as Akarshi mentioned, we can keep on revising every 3-4 years of our will. What is the rule around multiple versions? Is it a effective version of multiple wills, or the last will is the overriding one?
So any will, even online simple wills, they start off with sentence which says, I hereby denounce or declare
Okay.
all my previous wills as invalid, and this will be considered. So, and there is a date on which it is signed and executed. So, of course, the last will is your
Even though
Fine.
it
Even
comes
though
in
there
one.
were exclusive areas covered in two wills, the previous will be cancelled altogether. So if
Yes.
I've spoken about certain beneficiary in previous will and this one is an additional one in this new one, the previous one is gone altogether.
Yeah, so let's say if there is a dispute, if someone has been named beneficiaries in your first version and they have been removed in your second version, and if they have a dispute, then yes, the court will generally look at both the wills to see if this was actual the second will was genuine or not. But if, as long as the genuineness of the
Genuine.
latest will is established, then the last will that you've made
Previous one
prevails
is
over
disqualified.
all
Okay,
your wills.
okay.
Yes.
That was one question. And
You would refer to all the aspects that you want to change in the new will, and you normally want to put a reference to the earlier will in your new will. I made a will on January 24, and in December 25, that will is being changed because of ABC. That's one way of doing it,
was
possible.
it similar to changing the constitution? Is it you have to make those amendments recorded properly? Is that what you're
It's
suggesting?
better so that there is no challenge sometimes.
Yes.
Yes.
Okay.
So
Good
with
suggestion.
will, nothing is assumed. So it has to be written. For example,
Okay.
if you have four children and if you want three of them to get something and one to not get something, you have to write in the will that I don't want my four children to get anything because he is already very successful, or whatever reasons, or
Yeah.
not
Yeah.
even
Yeah.
not
Yeah.
even if it's.
Need
But
to
then if it's,
explain.
yes,
Yeah. Yeah. Need to
yeah. But
explain.
if it's not,
One will where he said that he never took care of me, so I don't want to give it.
Yeah. I'm
yes,
conscious of time. Sorry.
yes.
I'll keep on asking few quick critical questions. What is the minimum age for writing a will?
As soon as you're a
Any-
major, I would think, isn't
yeah,
it?
yes. Anybody
Or is
over
it
the age
not
of 18.
13 or 14 or something? Major, is that what it's suggesting? Or 18? What's the major age in Australia?
18 legal age.
Legal age, not
Yes.
13 or 14 when they start working.
No, 18, if because below 18 they are generally considered minors.
Yep,
So a will can be written by
sure.
someone who's got the
Because,
capacity to do other things.
and
But a
it's,
guardian of a minor should be able to write a will, I would assume.
Guardian of the minor can, yes.
and it's advisable to write it as early as possible, right? Because nobody can define what's, so
Yeah,
it's,
when what will happen, yes.
yes. And do we need to give a copy of will to executor, whoever we list as executor, we need to give a copy to them, right? In advance, early on, right? When we sign. That's a
Yeah,
general recommendation, yeah?
absolutely. Like what we discussed, because if at least 2, 3, 4 people who are part of your will knows it, that's when there's a chance of your will being executed. But so yeah, the answer
And
to your question is good.
Again, Suryaji, you may want to give it to him in a sealed envelope or in a locker or whatever. That's fine,
okay.
right?
Yeah,
That's depending on your circumstances, how
Okay, yeah,
much you
if
want
that's what
out.
you mean, yes.
good point.
The reason why you don't want to tell people this is coming to them are fairly obvious. That's something you need to understand. But it's important that someone knows that you've got a will and that needs to be executed. That's the most important part.
Yep. My next question is explicitly asking that question is that by design, by law, will is not a private document. It can be made public if needed, right? It's not a absolute need to be kept private until last time. Is so there's no legality that it cannot be made partial public or fully public. Is that right? It's legally required to be kept private and confidential all the time, or what? Like, what's the rule around it? Privacy.
You would register it in some states, right, Aakarsh?
Yes.
So
So
you can register a will.
yeah.
Yep. Good suggestion there.
Mm.
And
I was feeling just to answer that again, Akarji is the better person to answer, but we have seen and read so many times that so and so person has given so much asset in his will to this. That means he's made that part public. So I guess it's the individual's choice to make what public and what private, which is will. Obviously, like Neelesh ji said, nobody wants to disclose everything, because otherwise there is a chance of, kind of not being able to financially manage things well before it happens.
or we can say that
And
he's my executor. Go and check with the person. My will has been
Oh
returned. It's
yes,
public. Yeah,
that's what most of the
yes,
times that's what
yes.
happens.
yeah.
And
Uh,
with the will, then of course before the death it's a private document. After the death, once the probate is granted, then that's when it becomes public. But for the probate to be granted for any will, the court will only and only accept, in very rare circumstances, they will accept photocopies, photographs of will. They will accept the original document
mm,
with, if it's a multi-page, then with single stapler on it, not even two staplers, because if there are two
oh,
staplers, they have reasons to believe that something has been tampered. So
oh,
this is the extent it goes to. So if somebody writes a will and puts photographs on Facebook and says this is my will, it may not even be accepted because it's a copy of a photograph.
nice. Yeah.
And right now, you can create anybody. I can create, Mark Zuckerberg's will just for fun and say he's passing everything on to me.
Yep.
But that means nothing. So
We've
yes.
got a notarized copy of Prime Minister VP Singh declaring that he was mad. That's actually happened before AI came in. But the point, Suryaji, is why would you create a problem and have a fight within your beneficiaries before you die? It's always better to go and then let them
Yeah,
solve
I'm
it
just
out. But if you're
hypothetical
having
question, hypothetical questions. Yeah, but my question was around that who will read the will during emergencies? Like if somebody's gone, that do this and do that. Who will go and refer to the will component for medical situation, for example?
which is why you must share it with your family and your
And that's the medical power of attorney. That's not will, Suryaji.
Okay, that's outside the scope of
That's
will.
another document which is
Okay.
called medical power of attorney, which you use during the lifetime to expressly mention your intentions, which, obviously, again, whosoever the power you give to will have that power. And of course, that power needs to be told to that person and given him the document. Otherwise, how will he execute that document?
Yep. I'm conscious of time. Last two questions. One is that do you need to define all the tools like trust and everything, or as you said, it need to be explicit is better. But you may want to leave at the point of time in future. There may be other tools, better tools, alternative tools, which are more tax effective or whatever it may be, to allow dictionary to choose, the executioner to choose those alternative better tools at that point in time, or it has to be explicit early on.
Yeah, early on. It can't be done later.
And I'm not clear on the term deceased estate. So
Deceased estate means basically,
is it
say
a
if I
tool?
die, my assets will automatically be called as a deceased estate.
Not the property. We're not talking about property. We're talking about the entirety of the asset.
So all the assets, so basically Vikram Jain will become deceased estate of Vikram Jain, whatever. So
Okay.
that's my new personality, which is not me now anymore.
Yep. I think I've taken so much of time, but
And I
it
think
was
the best advice I will say to everyone is enjoy your money while you have it and while you can enjoy it. Can fend for themselves. The beneficiaries can fend for themselves. Just enjoy it first.
golden words in the very end, and
Exactly.
thoroughly, even though it was very sensitive, touching topic of death, but we are openly, very thoroughly discussing it, and really enjoyed all the aspect and directions notes you have given. I just logged into my super to quickly check this binding death nomination form. I have to explicitly fill a separate form. Otherwise, it's a automatic one is discretionary one. I didn't
Correct.
realize.
That's where fight happens between beneficiaries and they
Yeah.
can contest it. Yeah.
So
And that can be a strategy. Let them fight over it. That can be one of your issues with some people.
And we may think that our family, immediate family, like our children and partners, are not going to fight with each other, but there can be a dispute raised by our siblings, our parents, our someone. They might come and say, like we had a situation where a step son who never really did anything for the dying father, he came and suddenly said that for the last 2 years I lived with my father because he said, if you live with me, I'll give you part of my estate. At the time of death, the father left all of it to the daughter who took care of him, but the son still challenged it, and he got a share. So yeah, because the father didn't write in the will that no, I'm not giving anything to my son.
yep. I think time
I-
to wrap up.
Can I just request everyone to say thank you to firstly Suryaji for hosting this and Vikramji and Aakarshji for the time and their commitment to this. Surya.
I wanted to say thank you to all of you, all Neelesh ji, Vikram ji, Aakarsh ji, and definitely thank you to all the audience as well for
Yeah.
attending this very sensitive topic, very important topic. Please make sure you share this video to many who would not have attended this live session and watch it offline, because this is critical. There's a big gap in our community. And I really wanted to do this topic to be covered into this VICHAR webinar series for very long, from the day one itself. And luckily we found not just one, but three experts coming together on this very important topic. With that note, I think the entire community should learn out of this, get food for thought and start. And as I was having a question myself, doubt myself that will estate be written only once. It's not the case. You can revise, write something, begin with something bare minimum, then improve upon it, review it every 2-3 years, and definitely take your advice from the expert and that get proper advice from a financial planner and your accountant and all. And it's only in education purpose only, this webinar. And definitely keep bringing more ideas and community issues through this webinar series. And I request all my speakers to recommend more speakers for these future webinars, new diverse topics. You have lots of connection yourself, and let's grow and support each other, protect each other, and we enjoy our life. Neelesh, you've made very golden words for that. Let's enjoy whatever we have while we are alive.
Yeah.
So definitely, it's a very happy thought to
It's a
conclude this
pearl of
webinar.
wisdom.
Yes, yes.
Yeah. Suryaji, can I say
Yes,
in
Vikramji.
1 minute?
Yes, please. Yeah.
Yeah, Vikramji and Mr. Akash, your explanations very clear and insightful. And of course, Neeraj, your coordination in this important topic is truly commendable. And in notes chat, I have talked about, medical power of attorney, which is also very important, and medical power of attorney or enduring power of attorney. And I mentioned this jurisdiction part also. And recently, one of my friend, while moving the lawn, he passed away. And then Vikramji has helped me a lot in tax part and everything, because her daughter is a major. So, he has helped. And then without even deducting any tax, he has sorted. So Vikramji, thank you very much. You have helped us a lot. And another part, there was no will. So I myself was asking and taking care of with this family. So I myself has asked the lawyer and everything, and they were charging 4,000 to 5,000 for the letter of admission. So I myself went to the Supreme Court and sorted all those things after advertising and everything. So my request is to, make will each and everyone. Thank you once again.
Thank you, Vimalji. And as missed to mention in the welcome and introduction part, that you are professionals later, all of you are very good community leaders and your supporters, and you spend a lot of time for the community. And this is what we want to inspire young people as well. More young people come forward. As we said, nobody knows what the end time is. Whatever time we have, we should enjoy, we should help support community, we should interact with the community. And that is the biggest asset we have, and there's nothing to do. More you grow, it's you will not reduce that asset. You will grow, keep on growing on that one. So with that note, thank you everyone for staying late tonight, and as usual, please joining future webinars, and good night to everyone. Namaste.
Good night.
Thank you, everyone.
Thank you. Thank you.